And President John Dramani Mahama has been petitioned to remove Supreme Court Justice Yoni Kolendi over alleged interference in administration of justice. Meanwhile, former Attorney General Godfred has urged the Legal General Counsel. I beg your pardon, let's go straight to the specifics. I'm actually bringing you the headlines again. But the big story this evening is that barely 24 hours after petitioning the Criminal Investigations Department to investigate Justice Yoni Kolendi and Richard Agyapong over alleged interference of administration of justice, Daniel Mafu Ofori Atta, a Chebi indigene, has escalated the matter to the presidency. This time, he's asking President John Mahama to remove Justice Yoni Kolendi as a Supreme Court justice, accusing him of improper interference with the trial involving Dr. Ato Forson, who is the current finance minister and at some point the minority leader in parliament, and two others. So what exactly has been ongoing? And also you would recall that there have been petitions and counter petitions to the CID over these two gentlemen. I'm talking about the former Attorney General Godfred and then also a counter petition asking for a similar action by the CID to be taken against one other. So what exactly is this back and forth? Why do we seem to have this legal tussle vis-a-vis security concerns being discussed in the media? We'll try and get some specifics into why now the president has also been roped in, because a justice of the Superior Court is part of the conversations, and he's being asked, the president is being asked to ensure that he also considers removing him or kicking him out as a justice of the Superior Court. Dennis Pwaberi Wedam is with our research team here and also producer of Ghana Tonight, and also a lawyer, respectfully, would try and walk us through what seems to be quite an entangled subject matter. Dennis, good evening. Thank you for joining us on 3FM.
Always a pleasure being here, Martin.
So, to start with, there was a petition to the IGP when it has to do with Richard Agyapong. Then later, we were told that another petition has been sent there. Now, there seemed to be Yoni Kolendi who's been dragged into the issue. So something that was clearly a legal matter has security angles to it. And now the president has also been brought in. Try and, unpack all of this for us.
All right. So, Martin, let's go back to 2024 when the former majority leader, now finance minister, Dr. Ato Forson, was standing trial with two others in respect of the ambulance purchase case. So it came to light during cross-examination that there was some, then Godfred was the Attorney General who was leading prosecution in that particular matter. It came to light that the Attorney General then had some encounter or some interactions with one of the accused persons, who is in the person of Mr. Agyapong, then a businessman. Now we know he's in charge of special operations at the National Security Secretariat. Then that became a controversy in itself as to why a lawyer who is on the other side, in the person of the Attorney General, who is supposed to lead prosecution, would have such an engagement or an encounter with an accused person who is represented by a lawyer. The circumstances of this meeting in itself is strange, and at some point admissions will be made that then indeed that meeting was held, but as to what the meeting was intended for, it has different interpretations to it depending on who is saying it. So this meeting was between Godfred, Richard Agyapong, and then His Lordship Justice Yoni Kolendi, who we are told is a cousin of Richard Agyapong. This meeting undisputedly was held in the residence of His Lordship Justice Yoni Kolendi. So that particular meeting, together with some conversations between Richard Agyapong and then the former Attorney General, would be the basis for all that we are seeing today. In fact, it has even got so intense that the court itself had to make a determination in respect of that matter, because when it came to light that there was conversation between the former Attorney General and then the accused person, then the lawyers for the accused person said if that was the case, then it means that the trial itself was tainted. So they filed what they call an application for mistrial to say that the trial was being tampered with. The court had to make a determination. The state then opposed the admission of the conversation between Richard Agyapong and the Attorney General by way of WhatsApp messages and audio recordings. They wanted to take that out of the record so that it's not admitted into evidence. However, the court admitted that into evidence, but also rejected the application for mistrial. So what it meant is that, yes, we will look at the recordings as part of the body of evidence in the case itself. However, we will not throw away the case. We don't think that that conversation tainted the case so much so that we cannot proceed with it. That ended the matter for that particular one. But mind you, it got to a point where prosecution had closed its case, accused persons had filed for submission of no case. That's to say we don't have a case to answer. And if the court had agreed with them then, it meant that the case would have ended. But the court did not agree with them. So that's how come the High Court was still on it. However, on appeal, the Court of Appeal said the accused persons did not have a case to answer. And that's how come Richard Agyapong and then Ato Forson were acquitted and discharged. So it meant that the case came to its logical conclusion in the absence of any appeal on that matter. However, what still persists now has to do with the conversation which purportedly happened between the three people, Richard Agyapong, Godfred, and then His Lordship Justice Yoni Kolendi. We were learning just last week that Richard Agyapong goes to the CID to file a complaint that the attempt or the conversation that he had with the former Attorney General, Godfred was an attempt on the part of the Attorney General then to elicit favorable responses from him so that they could convict the now Finance Minister, who was also the first accused person in that case. He says that that conduct of the former Attorney General constitutes a crime for which the CID should look into the matter. As part of that conversation, he also did mention that at the point, Godfred had suggested to him to get a fake medical excuse to submit to the court so that he would not appear on court on a certain day. That he sees amounts to fabrication of evidence, which he contends that it's criminal, for which the CID should take interest in the matter. Just a week after that, another Ghanaian citizen, at least that's how he describes himself, also files a complaint at the CID asking for an investigation into the meeting that took place between Richard Agyapong, Godfred and His Lordship Justice Yoni Kolendi. He also says that that meeting was for the learned, Justice of the Supreme Court, Yoni Kolendi, to impress upon the Attorney General to let Richard Agyapong go because there is some family relationship, because Richard Agyapong is a cousin to Yoni Kolendi. He contends that that meeting is not appropriate in the eyes of the public, for which they have to look into it. He says that it is an attempt to obstruct justice, and for which, if it is indeed found to be true, constitutes crime. So that was the context for the CID part of it.
Okay, and that is the specific issue of the meeting between Richard Agyapong,
yes,
and Yoni Kolendi, who is his cousin,
yes,
and the fact that he was a Supreme Court judge.
Yes,
it was, according to this petitioner, it was wrong for that to have happened when there was a live case in court.
Exactly. And he even went further to impugn meaning into the meeting, to say that that meeting was purposely designed to impress upon the Attorney General to do certain things to let Mr. Richard Agyapong go. So for him, there was a crime to be looked at. That's how he petitioned the CID to also look into the matter. That was just yesterday. There are also reports that the same person has submitted a petition to the presidency now seeking the removal of His Lordship Justice Yoni Kolendi based on the same set of facts. At least that's what we are hearing. And that is so because we have not seen any official communication from the presidency indicating the receipt of that petition, knowing that these petitions, typically, they are in camera. And when we say in camera, it starts from the submission of the petition to the final determination of the matter. So within the context, it's only a purported petition which is said to have been before the president, and that it borders on this same set of facts that we had seen in the petition which has been presented to the CID. So to that extent, we are only limited in the scope of what he presented to the CID as being forming part of what possibly would be before the presidency in respect of this particular matter. So, Martin, that is how the matter is panning out. The case itself has ended in court. However, there are still concerns that that particular meeting should be looked at, so that if there's anyone who is found culpable of committing any crime by way of obstruction of justice in any way or form, that person should be held accountable for that.
In relation to it, we know that some responses have also come out where we are told that Godfred, for instance, has responded. Do we know whether it is to the petition to the CID, or this is the, now that we know, a petition to the president?
Right. So that is also a different forum altogether, if I may put it that way. Because while all this was happening, mind you, these two petitioners or complainants, depending on how you look at it, they put their issues before the CID. There was one other person called Daniel Kwame Ofosu Appiah in May 2022, who also said Godfred, beyond being the Attorney General, is also a legal practitioner, is a lawyer. And to that extent, the conduct, still using the same set of facts and then the same meeting and the interaction between himself and then Richard Japa, constitutes a professional misconduct. And as lawyers, the body which is in charge of dealing with matters of professional misconduct is the General Legal Counsel. So to that extent, he filed a complaint before the General Legal Counsel to look into matters of professional misconduct in respect of the former Attorney General. That is what we are now getting a response from the former Attorney General in respect of that particular complaint that has been made before the General Legal Counsel. So what this also means is that the General Legal Counsel has received a complaint. They forwarded the complaint to the former Attorney General. These are complaints that have been made against you in respect of professional misconduct. Look at them and offer us a response. This response, we now have a copy of it, which he has responded at length to all the matters that have been raised in that complaint, including urging that the General Legal Counsel dismisses the complaint for it not having any merit. Okay,
so let us get portions of that, but maybe before we come to the specific responses from the former Attorney General, let's listen to what a private legal practitioner, Martin Pebu, has been saying. Now, he spoke earlier on Ghana Tonight and said that the petitions are worth investigating to get the final outcome of the true incidents, and it clearly is an interesting position he shares. Many actually thought that he probably would have been one of those who would ask for it to be dismissed, but it looks as though he says that clearly it helps our legal jurisprudence, so it must be looked into. Let's listen to Martin Pebu now.
Somebody will say luckless coincidence. Another person too will say a very well orchestrated attempt to neutralize the Japa petition against Godfred. Yes. So we would never know which one is really the gospel truth, if we may call it so. But in such is life. Sometimes you may never know the real story behind the story. So we'll take it like that. But on the face of it, since this second petition is also presented as an attempt to get accountability, then it means that we have to give the petitioner his day in investigations, yes, instead of his day in court. We don't know whether this will end up in court or not. So we say his day in investigations, right? So let it go. Sometimes, as I said, because the key thing we should be watching is this. Because often citizens don't feel empowered, and some citizens are scared, and for so many other reasons, citizens generally don't like to take on persons in authority. I would say we should hasten slowly in condemning the petition. He's a citizen. That's Daniel Ofori Atta, right? Let him have his day. Yes, let him have his day. Because if we don't, then it would appear that we embrace Japa's petition against Godfred, but we are blowing hot and cold by summarily dismissing this Daniel Ofori's petition against Japa and Justice Kulendi. So for that reason, as I said, let's allow this one to also receive due process.
Right, so that is Martin Kpebu, a private legal practitioner. Dennis is still with us. So now let's look at the petition that was sent to the General Legal Council asking them to deal with former Attorney General Godfred Dame, and Dennis will walk us through. So what is captured in the petition to the General Legal Council? Is it just primarily to ask them to investigate and sack him out of the profession, that is? And what is the response he has given to that?
Well, so typical complaints to the General Legal Council in respect of professional misconduct would ask for things including generally taking disciplinary actions against a practitioner, which may include suspension. I mean, the extreme could be your name being struck out of the roll of lawyers. That means you have been debarred. But in this particular instance, we have Mr. Mafu, who makes specific references to some of the rules of ethics that he alleges that the former Attorney General breached. He says, for instance, that there was a failure to act with honesty and integrity and professionalism. He says that is a violation of the rules of that guide the profession. He also makes reference to engaging in conduct involving deceit and misrepresentation. He talks about direct communication with a represented party on matters of representation. He talks about attempt to improperly influence a witness and the outcomes of proceedings. He talks about a conduct likely to discredit the legal profession. And he also talks about any breach in the nature of the above. So he now says that the sanctions he is looking out for could include reprimand, suspension, or removal from the role of lawyers. But in substance, like I did mention earlier, all this is still predicated on that particular interaction between Godfred Dame and Richard Japa, and also that meeting that was held in the home of the respected Justice of the Supreme Court, Justice Yoni Kalondi. Now, having received this complaints from the General Legal Council, I mean, the former Attorney General being served a copy to elicit his response, he begins by raising some preliminary or addressing some preliminary issues, including the publication of the said complaint and referencing the rules of engagement, which say that such proceedings should be treated the same way we treat removal of so they should be treated, they're supposed to be dealt with in camera. And when we mention in camera, it rings a bell. It refers to the proceedings under Article 146 for removal of Superior Court justices and the Chief Justice. We've gone past all of those things before. So he essentially makes the argument that this complaint, even before it got to him, was well publicized, was on TV, was on radio stations and in newspapers, and that it was discussed extensively. He also makes the case that because it's been put out there already, it seemed to suggest that the complainant has a certain motive. He makes the case that even when this matter itself came up, there were some political undertones. So for it to be handled in that matter, he thinks that it's a breach of this in-camera proceeding for which it has to be dismissed. He goes ahead to cite a recent Supreme Court ruling in the case of Justice Tukono, the removal of the Chief Justice, in which the Supreme Court had refused to admit some of her affidavits into evidence for reason of those affidavits having to come from an in-camera proceeding. So he's urging on the General Legal Council to also adopt the same law or the same rule and then dismiss this particular complaint. But he says that if they are minded to proceed, there are even more weightier matters to look at, and that he did all he's alleged to have been done. Not to say that he has done them, but granted, he did them in his line of duty as an Attorney General. And he says that as an Attorney General, there's something we call prosecutorial discretion, which simply means that the Attorney General decides what kind of charges to prefer against somebody and when and how and all of that, including some engagements that they need to have to be able to prosecute their cases well, and that they deserve to have a certain level of immunity, so that once you become an Attorney General, you know that you are immune from suits and these kind of disciplinary actions. He says that even though this is not in our laws, he cites other laws from the US, from Canada, which seem to suggest that yes, indeed, typically there's that prosecutorial immunity. Then he goes on to address the specific matters of the allegations that have been made against him, and he answers each of them line by line, including indicating that these are even matters that the court itself had pronounced upon. And indeed, like I mentioned earlier, when this case came up for trial in that application for the mistrial, the High Court did indicate that they do not think that the interaction or engagement was to the extent of having influenced the case. That's how come that application for mistrial was dismissed, even though the exhibits by way of the WhatsApp messages were admitted into evidence. So the generality of it is that he contends, one, on the leg of even the jurisdiction of the General Legal Counsel to be able to hear a disciplinary complaint against a former Attorney General. He talks about the violation of the in-camera rule. Then he goes into the merit of the matter itself to dispute all the allegations that have been leveled against him. He says that he did not try to influence Jakpa in any way. He did not give him a coaching and all those things. So essentially, those are the matters that the former Attorney General has been addressing in this particular response to the complaints that have been brought against him for alleged professional misconduct in this particular proceeding. Martin.
Okay. Briefly, what does the legal counsel do when they get such responses? Is it that they write to you to get your response before they maybe convene a meeting or a committee to look into it? What really is the role of the legal counsel when it comes to whether or not a lawyer has misconducted himself and then some action needs to be taken?
Well, so look at it as a disciplinary committee. A complaint is lodged against you, Martin. You are there, you have no idea. What the committee would simply do is that upon receipt of the complaint, they'll write to you that maybe, for instance, Christabel has lodged a complaint against you. Find a copy of the complaint and provide us a response. Right. What we are reading is the response of the Attorney General. Now, there will come a point where they will invite the parties themselves to now come and meet the committee itself and make their cases known to the committee. But of course, the person who has alleged is the one who must prove. So there'll come a point where the complainant will be invited before the committee to furnish the committee with better and better particulars, and then the respondents, the Attorney General, former Attorney General in this matter, will also be invited. In these kind of matters, you are allowed to represent yourself or to represent by yourself or by a lawyer, almost taking the same shape as a courtroom, except that this is a bit more informal as compared to the courtroom setting. Okay. So we look forward to how this is going to pan out. But this is to establish the case that this matter is live and running. Unlike the cases before the CID and which we do not still know whether or not the CID has actually started its investigations into the matter. But for this, we know for a fact it's a live matter which is up and running. Right.
Dennis Puaberi-Wedam is with us, and with security-related matters now, because the IGP has been speaking and has sparked quite some debate. What's he been saying?
He, like you said, is suggesting after suggesting that communities in need of police presence should construct their own police stations. Appearing before the Public Accounts Committee on Tuesday, the police chief argued that community involvement in building stations could help address violent attacks on police facilities. His comments came in response to the recent attack on the
Yes, so you're referencing the Kukrantumi police station,
right,
by some irate youth, right?
Yeah. However, PAC chairman Abna Osei Asare challenged his position, saying such a policy would undermine the police constitutional mandates to ensure security and protect lives and property in every community across the country. Take a listen.
We all have to condemn the acts of irate youths always attacking police stations. There's a community in this country where we have one police station, which is a divisional headquarters being built by government. And then we have another that is the district headquarters being built by the locals themselves. When they were going to attack, they went to the building that was built by the government, they burned the building down. They came to their local building, then somebody said, no, this way it was the MP who built it, so let us not touch it. So they didn't touch it. And so today, when you are in your area and you are asking us, we should come and open a police station, we'll ask you to build a police station yourself. And it is when you build a police station, and all those areas where there are these disturbances, they never attack the stations that were built by the community themselves. And it is not good for this country. And so if you ask of closing down, yes, we'll close down because you have destroyed the station.
You just heard the Inspector General of Police, Christian Tete Yohono.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.